So this panel is on race and redistricting, and we've got an array of distinguished speakers who've thought a lot about this and been in the trenches in struggles about this issue. Our first speaker is going to be Terry Minnis, the Director of Census and Voting Programs, Asian Americans Advancing Justice. Our second speaker is going to be Justin Levitt, professor at Loyola Law School, who's also in the Obama administration in the Civil Rights Division of the Justice Department. He's going to be speaking instead of the listed speaker, Janae Nelson. Just something came up at the last minute, and we're really very grateful to have Professor Levitt with us. And then our third speaker is Thomas Saenz, President and General Counsel of the Mexican American Legal Defense and Educational Fund. Ms. Minnis.
Thank you, Professor Kennedy, and thank you, Miles, for the invitation to speak here today. As mentioned, I'm Director of Census and Voting Programs at Asian Americans Advancing Justice, AAJC, and we are located in Washington, D.C., and there are other Advancing Justice affiliates across the country, one in Los Angeles, one in San Francisco, one in Chicago, and one in Atlanta. I am going to give a couple of brief comments and overview around, there we go, Asian Americans and redistricting. And I think when I think about Asian Americans and redistricting, the phrase that comes to mind for me is, it's complicated. And that's because there has often been a tendency to carve up Asian American communities into different districts, reducing the ability of the community, right, to elect candidates of choice, and thus limiting really the extent to which their officials actually feel the need to identify or serve the community. So oftentimes I talk about what I consider one of the most egregious and illustrative examples of this, which is what happened to Koreatown in Los Angeles after the 1991 redistricting cycle. Koreatown, which covers only about 1 square mile, was split into 4 city council districts and 5 state assembly districts. So after the 1992 riots that occurred, there was about an estimated $1 billion worth of damages to businesses, a lot of them owned and operated by Koreans or other Asian immigrants in the neighborhood. But because the Asian American community didn't make up any significant portion of a representative's constituency, officials were really kind of left with little incentive to be responsive. And what ended up happening when the community went to different elected officials to try to get assistance in the recovery and cleanup was they sort of passed the buck and said, hey, you know, that's not my part of the district, why don't you go talk to Jan or go talk to Bob, you know, and it just kept going, you know, hot potatoes, if you will. So that is something that we see often happening to the community. But before we really talk about, and I know we'll get into it, you know, the issues around racial gerrymandering or partisan gerrymandering, which I know is a big focus, you know, for the conversation today, one of the fundamental factors at play for the Asian American community is actually shifting demographics. And I'm sure Tom will also talk about that for the Latino community as well. But we have seen, since the passage of the 1965 Immigration Act and the end of the race-based immigration quotas, the Asian American community has really exploded in growth across the country. According to the 2010 census, Asian Americans were the nation's fastest growing racial group, with a rate of growth of 46% between 2000 and 2010. Today, there are now over 19.1 million Asian Americans living in the country. Often viewed as a monolithic group, Asian Americans are actually exceedingly diverse with different needs. The fastest growing Asian American ethnic group were South Asian, and Chinese Americans continue to be the largest Asian American population in the country. One thing that a lot of folks don't necessarily know is that Asian Americans are also geographically diverse and are really growing fastest in non-traditional gateway communities. In 2010, the fastest growing Asian American populations were actually found in Nevada, Arizona, North Carolina, and Georgia. But of course, California still has the largest Asian American population by far, and that's followed by New York, Texas, and New Jersey and Hawaii. And then the other fact that I think is really interesting is that of the 19 states that are home to more than 225,000 Asian Americans in state, 6 of them are in the South and 4 are actually in the Midwest. So we're seeing this sort of spread of the community across the country. The last data point that I'll just point out right now is that the number of Asian American voters have actually nearly doubled over the last decade. From more than 2 million voters in 2000 to 3.9 million voters in 2012. The 2016 election actually saw over 5 million Asian Americans voting, representing a record increase. And about 1.14 million new Asian American voters entered the electorate, nearly doubling the average increase of 620,000 new voters in the prior 3 presidential elections. So, if the future rates of change are projected to based on these trends, Asian Americans should actually reach 5% of the voting population by 2025 and 10% by 2044. So what does this mean? We've seen Asian Americans beginning to translate this growth into political power and political voice, right? So during the 2011 redistricting process in California, the state's first Asian American majority minority district was drawn in the West San Gabriel Valley. Where Asian Americans make up 50.09% of the citizen voting age population in Assembly District 49. New York's Assembly District 22 in Flushing, Queens, which is represented by Grace Meng, is majority Asian population as well, making up 68.7% of the total population and 69.2% of the voting age population. So this is not really surprising, right? As I mentioned, these are the top 2 highest population, states with the highest populations of Asian Americans. Combined, they represent 7.1 million Asian Americans, and that's really more than 40% of the total Asian American populations in America, at least from the Census 2010 data. So I talked about the fact that Asian American populations are growing in every state, but their numbers often can still be too small to mandate the drawing of majority-minority districts, right? So while Nevada, Arizona, and North Carolina did see growth rates of 116%, 95%, and 85% respectively, those population numbers are still all under 250,000 or under 200,000 for North Carolina. So and I had mentioned the 19 states that have 225,000 Asian Americans each, but really Asian Americans generally make up only about 2 to 9% of their respective states' total population, and often may not be clustered in an area that make it easy or conducive to the drawing of lines. So because of this, Asian Americans actually relied more often on making arguments around communities of interest, right, and keeping them together, such as arguing that Koreatown and Los Angeles should be kept together whole in a district. So communities of interest are those defined by actual shared interests and needs, right? So it's not just to say, hey, this is an Asian American community and therefore we should draw that, because as we know, that is impermissible. But the idea is that there are shared factors or shared interests and needs that would indicate that they should be kept together in a district in order to have representatives that would actually be responsive to these needs. So one of the things that's interesting, I think, about looking at identifying community interests is there are a number of different data sources you can look at. Census, of course, being very important, which is why I know there's a panel later with our esteemed colleagues around the importance of census data. And I really want to highlight, this is really critical in being able to do this and do this right. If we don't have a fair and accurate census count, that skews the entire process from the very beginning. But other data sources, of course, include other governmental data, demographic studies, surveys, political information. Of course, it's also important to get feedback and input from those on the ground, from the actual local communities, to really get a deeper understanding of what's going on. And of course, community interest can be multiracial or different types of intersectionalities, as people like to say. And so that is something that is important to think about. And so some of the examples of relevant social, characteristics or needs and concerns can be cultural language characteristics, educational background, employment and economic patterns, health and environmental conditions, housing patterns, and so forth. And so just to give a quick little flavor for the Asian American community, I'll give a couple of data points that kind of often are used to kind of help build these communities' interests. One is that approximately 60% of Asian Americans are foreign-born. So, of course, there are certain needs that come out, that derive from that. One, of course, being language issues. So about 1 in 3 Asian Americans have difficulty with speaking the English language fluently or proficiently. And on top of that, one thing that's interesting is 1 in every 5 Asian American household is actually one where no one in the household who's 14 or older speaks English exclusively or very well, right? So this really means that these are households where all the adults have difficulties with English language. And so that can, for example, derive needs around language assistance from services like police or, healthcare and things like that. And so those are the types of factors one can look at to try to build these communities' interests. More recently, Asian Americans have also been looking to the creation of minority coalition districts to help ensure their voices are heard. So a minority coalition district is one where 2 minority groups or more have come together in coalition to constitute a politically cohesive voting bloc that could elect a representative of choice and where their numbers constitute a majority of their district. And so, and where that minority coalition actually satisfies all the factors under Jingles, then you can mandate the creation of such a district. And so I know that in Texas, for example, one of the House District 149 was in the last redistricting cycle, which I know there are many more experts that can get into it because it's massive. But just to say that we know that was the minority coalition, Hubert Vo's district, and so the community came together to really work to try to keep that district together and in the plan. So with that, I think I'll stop there and turn it over to Justin.
Great. Professor Levitt.
Thanks very much, Terry and Professor Kennedy and the Ash Center for hosting this event. I'm really delighted to be here. And even though I'm a poor substitute for Janae, I did have the opportunity to work with the NAACP Legal Defense Fund and a number of other civil rights groups, including Asian Americans Advancing Justice, on one of the recent briefs up at the Supreme Court, so not wholly out of my zone. I want to back up if Terry was giving you some stats at the 100-foot level, I want to back up to the 100,000-foot level, perhaps. And I want to bring you 2 pieces of good news in this area. And then, of course, I want to bring you down with 2 pieces of less good news. So the first piece of good news, it's 2017, and we no longer have to convince people, I think, that we're post-racial. Congratulations. Anybody who was watching anything over the last year, and anybody who was watching the elections yesterday, including some really egregious flyers in my home state of Jersey, knows that we're not over it yet. Of course, that's not news to many of us who work in this area, but I think it is becoming apparent to everyone now that we're not over it yet. We've had problems with race and redistricting for a very long time, as you heard Professor Kesar say moments ago, and we still have some of those problems. And in fact, just one footnote to the story that Alex was saying, the same justice who was urging that we avoid at all costs the political thicket, Justice Frankfurter, who was vigorously dissenting throughout the 40s and 50s. Well, he didn't have to dissent in the 40s. It was his view that was prevailing. But urging the courts to stay out of the redistricting process was also the justice who thought it wholly unexceptional to step into the redistricting process when race was concerned. A case called Chameleon versus Lightfoot in 1960, authored by Justice Frankfurter, saw absolutely no problem with understanding that this treatment of race in the redistricting process meant real power, and that was something that the courts could and should intervene in, and never mentioned the political thicket or the problems therein, because he understood the deep and abiding history and the continuing problems that we have with race in the redistricting process. So the problem is very old, and we know that it is still going on. There are still states and local jurisdictions that are redistricting in order to cause harm to racial minorities. Some of those are done out of animus. That's the good old-fashioned racial hatred. Some of them are done out of political opportunism, and that is also the good old-fashioned racial hatred. Many people seem to think that the choice of race or politics is mutually exclusive and that one is bad and the other is kind of okay. But actually, Judge Kaczynski out in the Ninth Circuit, in a case 30 years ago now, made this abundantly clear that if you are abusing people because of their race, the fact that you may be doing it for underlying political reasons is not actually an excuse. I can want to get rich all I want. That's fine. If I choose to get rich by mugging somebody, that's not okay. And seeking political power by mugging somebody on the basis of their race is also similarly not okay. And that's abundantly clear. The example he gave was in the housing context. Let's say, he said, you have absolutely no ill will toward minorities, but you're a landlord and your neighbors come up to you and convince you not to rent to any of those people because the property values are going to go down. Have you discriminated on the basis of race? You bet. Clearly. And not controversially. And that sort of political opportunism is also, unfortunately, alive and well. And sometimes there are toxic mixes of both. Texas, for example, has proven itself really good at this. They've not escaped a decade of redistricting since the 60s without a map being struck down. We're right on schedule. They are repeat offenders in this zone, and the tools that we have to confront that recidivism are decreasing. I'll get to that in just a second. North Carolina is joining them. Has always been striving for first place in the racial gerrymandering wars, but seems to be pulling ahead at the moment. The nice thing is that we can point this out without being accused of a retrograde analysis. It is becoming increasingly clear to people that this is, in fact, something that needs addressing. Again, not to people who've been working in this area, but I think the general public is coming to understand we're not past it yet. The second piece of good news is the courts are also coming to understand it. So there has been a lot of pushback against both forms, both flavors of abuse of race in the redistricting process. Courts have been pushing back in Texas, courts have been pushing back in North Carolina, courts have been pushing back in Alabama and in Virginia and they are not taking the excuse that's being offered, the Voting Rights Act made us do it, unless the Voting Rights Act actually did make them do it. We see a lot of jurisdictions in the 2011 cycle notably, although it's not new to that cycle, taking action that discriminates against racial minorities and doing so in the name of the Voting Rights Act. And the good news is the courts are seeing through it. And now the bad news, it's taking way too long. We're still fighting maps in Texas. The origin of those maps was in 2011. It's now coming up on 2018, and we don't have that conflict resolved yet. We are still fighting maps in North Carolina, where the legislature has done everything possible to stall actual fair maps in response to court rulings telling them they better get on road. And this is due absolutely directly, not everywhere in the country, but in many places around the country, to a 2013 case, Shelby County versus Holder. Shelby County gutted one of the essential parts of the Voting Rights Act, I know we'll talk about this as well a little bit later, that allowed, at least in some parts of the country, not everywhere, the federal government to step in and stop discriminatory maps before they ever took effect. In 2013 or 14, very shortly after the decision, I was testifying before a Senate committee with a gentleman named Michael Carvin, who said, don't worry, Shelby County is not that meaningful because you'll be able to get relief quickly when you need it. You just go into court, you get a preliminary injunction under a different part of the Voting Rights Act, we can still fix this. I said then that it was odd for an academic to be grounded in the real world and a practitioner to be off in fantasy land. And I think the academic has been proven right in this case. We're 7 years into a redistricting cycle, and relief is nowhere near in sight and has cost an immense amount of time and treasure in the process. And that leads to a second downside. Shelby County did something else in addition to stopping the ability to stop discriminatory maps before they occurred. It took away the early warning system. This is going to be most apparent, bringing us back to the topic of the day, redistricting in 2021, with race and redistricting. It's going to be most apparent in local redistricting. So when a state redraws the maps in order to discriminate, we'll know about it. There are lots of people watching. There are only so far 50 states. It's not that hard to figure out what the impact of redistricting is. It all happens at once. That's a tremendous burden on resources, but at least it's apparent. Local redistricting is a very different matter, and we are often way drawn to the shiny at the expense of the very real in local governance. And so when local districts all over the country redraw their lines in 2021, before Shelby County, many of them would have to report to the federal government about the impact of those lines. That is gone. And so one of the biggest problems coming up is one that very few people are talking about, and that is we won't know where the problems are anywhere near as reliably in 2021 when it comes to the all-important local elections, city council, county commission, school board. We won't know where the problems are. And that, unfortunately, is a piece of bad news that I don't have a good response for of yet. And now that I've brought you all down, I'm going to turn it over to Tom. Wholly unfair of me.
Thank you. So I'm an optimist, but I play a pessimist in most of my public appearances. And I'll do that here. Justin and I shared a cab yesterday, but we didn't know he was going to be on this panel, so we didn't have a chance to discuss what he would be saying. And I just want to dispute a couple of things. His optimism. I think within this room, it's certainly true we know that we are not post-racial. I'm not sure how far beyond the boundaries of Cambridge, Massachusetts that sense goes. And certainly there are parts of the country that are moving in the wrong direction toward normalizing and accepting what previously would have been more universally recognized as racially discriminatory intent. So I think we still have work to do in this room and beyond. In an age where there are limited attention spans, it is tempting to some with an appropriate focus these days on partisan gerrymandering to view racial gerrymandering as yesterday's news, the patterns of the past, something that we've dealt with appropriately already. And so I'm going to echo my two colleagues in trying to establish that that is clearly not the case. I think part of that inclination comes from a sense that partisan and racial gerrymandering overlap these days. And that is true in some contexts. But what we know where they don't overlap is that there is still racial gerrymandering and racial discriminatory intent in drawing districts. Justin talked a bit about the Texas redistricting case still not resolved, but now before the U.S. Supreme Court, which prematurely took up the case before the three-judge district court had yet arrived at a remedy. Clearly something ominous in their decision to reward what I had characterized in another context, the Texas Attorney General's penchant for premature litigation when he filed to get review in the Supreme Court before there was even a remedy, and with multiple orders telling him that there was no final judgment yet, only to have the justices decide to take the case. But that case involved congressional redistricting and state legislative redistricting in Texas. On the congressional side, it's important to note that Texas was the big winner after the last census, gaining 4 congressional districts. Now, 65% of the population growth that led to those 4 new districts was in the Latino community. And in its initial 2011 lines, the state legislature drew exactly 0 of those 4 new districts as Latino majority districts. And that's what led to the challenge. Now, there have since been put in place interim maps that convert 2 of the 4 to majority-minority districts on a hopeful note, but that's what this United States Supreme Court has decided to begin to take a look at this term. So we've seen the patterns of racial gerrymandering in Texas, and they continue elsewhere. Another area where it clearly does not overlap with partisanship is in nonpartisan races at the local level, which Justin also mentioned. So Maldiff is going to go to trial next month in December against Kern County, California. Kern County is where Bakersfield is. If anybody's been to Bakersfield, it is a part of the San Joaquin Valley, which is very uncharacteristic of the rest of California as people generally see it in the political sense. But Kern County is one of 9 counties in California that after the last census failed to draw a Latino majority county supervisorial district, either the first or second in the jurisdiction, when they should have, given population changes, given population distribution, and given the continued presence of racially polarized voting in the state of California. Nonpartisan races, but nonetheless, the growth of the Latino population viewed as a threat to incumbents of whatever party, and therefore creating problems with racial gerrymandering, with vote dilutive district drawing in those local jurisdictions. So the problem is still with us. And in some ways, it has evolved from what it might have been characterized as 25, 30 years ago. Because the problem more and more is one of a growing population, at least in the Latino community, where it's not about preserving majority-minority districts, it's about having to create more majority-minority districts. And that, much more than preserving majority-minority districts, is obviously a threat to those in power, whether that's individual incumbents, or a party, or an informal political grouping that has power in a particular jurisdiction. And that's what we grapple with, where that threat is perceived not so much in partisan terms, but in racial terms. The Latino population is growing. It's going to take more and more seats. We have to do something about it. That was perhaps most directly seen in the case in Pasadena, Texas, recently resolved, where the mayor actually said after Shelby County, now I have the opportunity to effectively stop that growing Latino community from taking a majority of the city council, and decided then to shift from 8 districts on the city council to 6 districts and 2 at-large seats, knowing that differentials in participation meant that the white population would control the outcome of the 2 at-large seats for a much longer period of time than they would retain control over district elections. Fortunately, a conservative judge saw through that and decided it was intentional, and not only ordered the city of Pasadena, Texas to revert to an 8-district city council, but also in the first contested post-Shelby County order, decided that Pasadena should be subject to preclearance of its electoral changes. So we see that, whether partisan or nonpartisan, still today. So within this room, I think we can agree that racial gerrymandering remains a problem. Still, as Justin said, there is a fascination with the shiny, which sometimes means that there's more attention on partisan gerrymandering than on the continued patterns of racial gerrymandering. So we must address these patterns. There are open questions. For the Latino community, I know that after the next census, assuming that we're able to get anywhere close to a fair count in the census system, which you'll hear later, something now in question, since only last Thursday, the Census Bureau pointed out to the National Advisory Committee that they're already seeing spontaneous indications of heightened fear in immigrant communities like the Latino community about participation in the census. And this is 3 years before we actually get to the count. But if we get anywhere close to a fair count in the census, then 2021 will present opportunities, will present an obligation to create additional, more Latino majority seats in jurisdictions all the way across the country. And that will precipitate more conflict that we must deal with. So I want to briefly touch on what Justin touched on. We need to find a more efficient way after Shelby County of dealing with these issues. We had a way with preclearance before, a much more efficient, cost-effective way. I mentioned we're going to trial next month against Kern County. I will tell you, as the guy who has to look at the finances, that's a very expensive case. We can only afford to bring a couple of these cases at a time, and we're a nationwide civil rights organization. Why? Because as you've heard, the operative test is totality of the circumstances. Even lay people understand when you tell them the test is totality of the circumstances, how costly that can be. How many expert witnesses, how many lay witnesses, how much preparation involved in bringing these cases. So we do need to ensure that we have a more efficient way of dealing with the ongoing challenge of vote dilutive districting and racial gerrymandering. Now, we had in place preclearance. That has appropriately been characterized as the most successful civil rights provision ever enacted in federal law. But I try to convince legal audiences in particular that it is not only that. It was one of the first and most effective alternative dispute resolution mechanisms written into federal law. Now, ironically, some of the political and judicial forces that love ADR when it comes to big corporations and consumers or employees, they don't love it so much when it has to do with voting and voting-related changes. So I have tried to characterize this as ADR to emphasize how cost-effective preclearance was. I know that it's an effective tool because I was once on an ABA panel with one of the litigators in the case of Shelby County, and after I said that preclearance was ADR, it almost became a mantra of his. He would say under his breath throughout the rest of the panel, "It's not ADR, it's not ADR, it's not ADR." It is ADR, and we need to get it back and get Congress to enact something that would permit us to more efficiently resolve these conflicts. The only thing I would add to that is we need to improve on what we had before. Because the challenge of communities, Asian American and Latino in particular, that are growing and therefore achieving more political power, potential political power, is different from a long-standing population, characteristic of the African American population and the Latino population in certain areas, a long-standing minority population that has a long history of having its voting rights limited, of facing discrimination in voting. In that context, the kind of preclearance formula we had before, based on a history of participation and violations in a particular jurisdiction, made sense. It still makes sense for those populations that are stable in particular areas. But when you have growing populations that are only now reaching the potential for political power, there isn't going to be that history. So we need a different ADR trigger for preclearance in that context. And so MALDEF and others have proposed, together with the Leadership Conference and Asian Americans Advancing Justice and others, a supplemental formula for preclearance that would recognize patterns, practices that have been used historically in many jurisdictions to violate voting rights, violate minority voting rights, and those practices, characterized as known practices under this proposal, would trigger preclearance review in any jurisdiction across the country. That known practices coverage, supplemented by the historical formula, would give us a very effective ADR mechanism to address and resolve these ongoing issues of racial gerrymandering and vote dilutive districting across the country much more efficiently and effectively in the future. Thanks.
Thank you very much. I've got a couple of questions, and I'm going to ask them, and then we're going to have plenty of time for questions, comments, and objections. The floor will be open, but let me start off this way. First, all three of you obviously feel under considerable pressure. So it's your posture was one of warding off difficulty. Let's flip it around. Let's imagine, for the sake of discussion, that you had convinced the American electorate you had brought the American electorate to your side, totally. And so you can do what you want. You have the power to draw the lines the way you want them to be drawn. What would you do? How should lines be drawn? what would be a good system such that you all could, go to a wholly new subject?
Well, I'll start. As you heard, redistricting is inherently political, small p. You can't take the politics out of it. There's no way of doing it. I think if you attempt to do it, sometimes you go too far. So whoever the decision maker is, you've got to have them follow fairly clear but necessarily amorphous criteria for drawing lines that center on communities of interest, but that recognize a tendency, historically and continually, to limit the power of growing demographic groups, often defined by race. And so you've got to put in place criteria that recognize the primary importance of ensuring you are not attempting to dilute the votes of minority groups, particularly if they're growing and therefore threatening extant political power, and then have criteria that are built around communities of interest. But you have to supplement that, even when I've convinced everyone in the polity, you do have to supplement that with some review mechanism. Again, the most efficient such mechanism is preclearance review. Now, that had historically, before Shelby County, been done at the U.S. Department of Justice level. Doesn't have to be. If we can't get Congress to move, then that preclearance review by an independent body can occur state by state. That's much more difficult. You're not going to get the sort of nationwide guidance and precedent that you got from DOJ review, but some sort of outside review. Currently, the only such review is in the court system, where we do have, as Justin mentioned, some courts getting it right. As more and more Trump appointees get confirmed to the court, that may not always be the case. So we've got to be concerned about getting some independent body still to review, particularly for those historical tendencies to limit the power of minority groups.
And one thing I agree with everything that Tom said. One thing I think that also is critical for the redistricting process itself is to really create more transparency and accountability within the process, right? So I know that there have been massive efforts in states like California and states across the country to get regular citizens to participate or not, to engage in the conversations and to, provide testimonies, provide maps, provide data, and the like. And in a lot of cases, it's like throwing it into a black hole, right? So one thing that I've thought about in the past is, really trying to make whatever that redistricting body is have to be held accountable to the public, right? So whether it's modeled off of like how the Federal Register notice process works, where, the receiving agency, or the redistricting body in this case, would have to respond to the comments, the testimony, and say, yes, no, and here's why, right? That's one thing that I think would go a long way to maybe also helping with some of the litigation efforts to have that record so that maybe some of the resources can be diverted elsewhere.
Let me just say, in a law school, I would just add to that and say what we need is advance waiver of legislative privilege. No matter who is drawing the lines, this is such a small p political area that it makes sense to take away that legislative privilege. I will tell you, when we litigated against California redistricting last decade, we knew that behind closed doors, the legislature said lots of very explicit race-based things. We could get none of them into the court case because they asserted legislative privilege and it was upheld by the court. There should be an advanced waiver of legislative privilege when it comes to line drawing.
So the nice thing about this is I can agree with everything that has been said so far. When Professor Kennedy posed the question, it's a question I don't usually get to contemplate until after I've had several drinks. And it's too early for that this morning. As a civil rights lawyer, we're always looking to put ourselves out of business. There's nothing we'd like better than to put ourselves out of business. It's just that business has been booming for quite some time. So what does it look like when it's all better? Equitable representation is really a different way of saying exactly what you've heard here. The genius of the Voting Rights Act actually is that it does not take a position on what equitable representation looks like, except you can't discriminate. It doesn't tell you where to draw the lines. It tells you what not to do. And that leaves abundant differences of opinion for local jurisdictions, exactly as Tom mentioned. I agree. The process is political. By the way, just a word on that, because we're not going to be sitting up here for some of the later panels. That does not mean it has to be inherently partisan. It's different. The fact that the process is political means we don't all agree on what we want districts to look like. There are political choices about whether you follow municipal lines or county lines or rivers or railroads and in what degree, about who gets what kind of voice in different areas, about the types of communities, whether it's the tech community or an agricultural community, whether they should be within one district, whether they should be split across several districts, whether in the northwest of a state, some of those things are far more important than in the southeast of a state. Those are all permissible political calculations, and we don't all agree on them. It's also the reason you can't just redistrict by computer, because somebody's got to program the computer. And it turns out whoever's programming the computer is making choices about what redistricting looks like that we may or may not all agree with. But the one thing that is constant is a desire for equitable representation of community. I mean, you've heard it from Tom, you've heard it from Terry. I want somebody that has my interests at heart when they're representing me in government. And sometimes that will look like somebody who has my racial or ethnic reasons at heart. Sometimes that will not. The genius of the legislation so far has been an anti-discrimination mandate without imposing a particular either structure or particular set of governing lines. And I think that's appropriate. What you've heard is we want the process to be able to work out where people get to argue about this stuff. It's just that you don't want it to come at the expense of minorities posing a threat, and that has been way too frequently the case, that district lines have been drawn on the backs of minorities who are perceived as a threat to the incumbent power structure. That's what we have to get away from.
One more question from me, and it has to do with majority-minority districting as a way of protecting minority electoral power. Of course, there's some people who engage, or some parties who have engaged in majority-minority districting as a way of cabining minority power. How does one distinguish between when majority-minority districting is being used on behalf of racial minorities as opposed to against racial minorities? This has generated all sorts of interesting bedfellows and interesting allies and also interesting adversaries. This seems to be a real, in the last few years, the Supreme Court has grappled with this, and, well, what about the present state of majority-minority districting? How do we tell when it's good? How do we tell when it's bad?
I want to fight the premise for a second, and then I'll let Tom tell me why I'm wrong, because he will. Majority-minority districts is a shorthand. There is no requirement in any piece of law or in the Constitution for majority-minority districts. Let me say that again. That is not a thing. What is a thing is effective, equitable opportunities to elect a candidate of choice. That's actually the opportunity to elect a candidate of choice is the language in the Voting Rights Act. And that is incredibly nuanced. It depends on local demographics. It depends on local political patterns. It depends on what the community actually looks like, how severely they may have been handicapped by discrimination, keeping them from the political process in the past, what turnout rates are, what the other rules of the election are. You cannot say that 50% plus one is an equitable district in the abstract until you tell me a lot more about the community, about where they are, about what they've had to go through in the past, and about whether that allows effective opportunity or not. Sometimes it's going to be more. Sometimes it's going to be less. In North Carolina, this last cycle, the North Carolina legislature essentially said 50% is nice and even and a simple number. And so even though we know that the African-American communities in North Carolina are electing representatives of choice at a lower percentage within a district, we're going to make sure that all of the districts are majority-minority. they held that up as complying with the Voting Rights Act, and really it was a cynical attempt to overpack districts to deprive that community of power in surrounding areas. But that's because there's nothing magical about majority-minority. What's the magic is in an effective opportunity to elect candidates of choice, and that's going to vary tremendously based on the history and based on the region.
So I don't disagree with anything Justin said. I would just add that, of course, we're all concerned about packing. It is another way of limiting minority voting power. And here you have to be wary of the views of even minority incumbents, because everybody wants a safe seat. And so we have often been at loggerheads with Latino incumbents who want their districts to be very, very, very safe at the expense of potentially creating greater influence or even another majority district in the neighboring vicinity. So you've got to be sure that that independent review evaluates the positions of incumbents and incumbent parties with a significant grain of salt, as it were. I think you also have to make sure, because it is an art and not a science, of course, that you are often reviewing whether patterns of racially polarized voting continues. In theory, it is possible that a jurisdiction reaches a point of political maturation where there is no longer significant racially polarized voting, and in that context you have to question whether you still need the majority-minority districts. Now, you have to continually evaluate, because racially polarized voting changes over time and can go different directions. I think when we talked about this panel, I said one of the big questions we will face in 2021 is whether Donald Trump's effect on racially polarized voting has actually increased it. And in some geographies, that will probably be the case, that his appeal to white voters will accentuate and make more prominent racially polarized voting. It's also conceivable in other jurisdictions that he will have alienated so many moderate white voters that you'll see a diminution in the significance of racially polarized voting. And that's a question that we're all going to have to evaluate with the help of experts come 2021 in the next round of redistricting. But that independent review has to have an eye to an ongoing evaluation of patterns of racially polarized voting within any geography.
And the only thing I would add is that, once again, it's so critical to actually engage with the people that are impacted, engage with the communities that are being impacted. A lot of times things can happen, it seems almost in a vacuum, and people may get accused of swooping in and doing things and leaving without ever really talking to those who are going to be left with the results of that effort. So I would just flag that, in addition to all the brilliant things that have been shared by my colleagues up here, the simple, basic, you got to go to where the people are and talk to them and figure out what's going on will help determine whether or not the districts that are being drawn are actually being drawn on for their benefit or not.
Questions? Yes, sir. I think a microphone's being brought to you.
Thanks. Jed Schwartz from Somerville. A question from the admitted ignorance is, are districts determined more by geographical magnitude, miles, square miles, acres, and so forth, or by population density? Because, this would be fairly easy to determine, because, I mean, if you have a rural area with an enormous geographic area but very small density, very small population magnitude, then you have the explanation for. It's a different explanation than simply race. I mean, if you can interject race into, if you require that each district have approximately the same number of citizens, voting citizens, then the advantage of rural representation, which is largely Republican, is considerably reduced. And they say, I don't know whether there is a requirement for equal. You get the. Maybe somebody on the panel or does. Hopefully, they do.
So, thank you. We should have said that, according to the Supreme Court, districts have to be equipopulous. So you are looking at the total population, not the voting population, but the total population. And for congressional districts, they literally have to be as equivalent as possible, so one person apart at most in a particular state. For other seats, state, legislative, local, you have to have roughly equally populated districts. The percentage deviation rule of thumb says it can't be more than 10, probably significantly less, but sort of more in the eye of the beholder. But districts must be drawn based on total population under our Constitution.
Has that always been the case?
No, that goes back to one person, one vote in
Professor Keesar. Yeah, it was, so Professor Keesar mentioned in the 60s the sort of entry of the court into what they called the reapportionment revolution. Again, not the first time they took redistricting cases, but the thing that Chief Justice Warren said was among his most lasting and important impacts was the basic decision that districts should be based on population.
Yes, sir. Man in red.
I was wondering if you could say a few words about the idea of proportional representation, a way of sort of cutting the Gordian knot of all these issues, and especially modern proposals for proportional representation, which can work on top of existing districts and using existing machines. Mm-hmm. Thanks.
Terry's looking at me and saying that's a very academic question. So sure. We are not the only country that elects people to stuff. And it turns out that there's an awful lot to learn from other countries that have elected people to stuff, including countries that have looked at our system and said, hey, we can maybe do better than that. Proportional representation doesn't exactly cut the Gordian knot, because proportion of what is still a really pressing question. We don't all agree on exactly how we should be divvied up proportionally. Some people think party is super important, some people think ethnicity is super important, some people think other things are super important. That said, there are a bunch of different systems in and around the world that make individual lines less important and account for a different way of tallying votes and a different way of voting, and that tend to take some of the racial and ethnic pressures out of the system, that take some of the partisan pressures out of the system. They are by no means perfect. If you look around at some of these other countries, it is not as if they have resolved all of their ethnic or racial difficulties either, but they go a fair distance toward mitigating some of those impacts. Curiously, some of those countries that have built different systems for the way we cast and count ballots that take some of the pressure away from individual district lines have also allotted a particular quota for traditionally underprivileged racial minorities. And that's something that I think the Supreme Court has pretty emphatically said would not be possible here. There are elements of some of these systems we could adopt. We've had some of them over time. So state legislatures looked very different in the 19th century than they did today, and Illinois used a system for 100 years that combined some of the elements of this particular system. We could go back there, and there are groups that are advocating very strongly for us to go back there. It takes the ability of Americans to conceive of a system different than one legislator, one district, one way to cast a ballot. And thus far, our ability to learn from others is probably the single biggest thing that's getting in the way.
Well, I have to add to that, the non-academic perspective. You count me as an extreme skeptic when it comes to alternative voting systems because we lack the constitutional power, as Justin has mentioned, to control for very significant differentials in political participation between racial ethnic groups. Some of that is because of eligibility, non-citizens, those under 18, etc. So they tend to get discounted in alternative election systems. In addition, we still have, even among eligible voters, very significant differences in participation. And until we successfully address those, and there are ways to do it, but we as a society don't invest in them, without the ability to control directly constitutionally for those differentials between racial ethnic groups, then I think we're not yet ready to adopt these alternative election schemes in this country.
I really do
really quickly just wanted to highlight something that Tom had said. And I think one of the key things about any type of proposal is whether it is comprehensively looking at the impact on all the different communities. Not paying lip service to it and just saying, oh yeah, this will be beneficial, but doing the actual analysis and finding ways, right? So one of the issues I think would be with respect to any alternative voting system is, are you actually properly educating people who, as Tom said, aren't already participating in the process, and then you're going to throw this more complex system at them, and are you actually engaging people? And is that a critical component of any type of program and not just a throwaway or an add-on?
I was going to say, I welcome the question insofar as it seems to me, given our crisis of democracy, we ought to be thinking very broadly. I would think especially for small minorities as opposed to larger minorities, the issue of proportional representation would be more attractive, actually. I have a colleague here, her name is Lonnie Guinier, and of course, several decades ago, she floated various theories of democracy that would be more attentive to the problem of racial minorities who would face the problem of, dilution, who would face the problem of submergence. Of course, her voice in practical politics was repressed, but the idea and the ethos behind the views that she voiced, it seems to me, we ought to still be thinking about. Now, that doesn't mean one ultimately embraces them. Maybe one, upon thinking about them, upon asking the various questions that have been proposed, you reject them. But the idea of thinking beyond what we currently have, it seems to me, is rather essential. Other questions, comments? Yes.
Good morning. I wanted to speak a little bit about the reaching into the community point that the young lady on the panel brought up, because I think it's a really important point. Can you hear me?
Yeah.
Sorry. I'll speak louder. Redistricting is a very complex topic, and the vast majority of voters and citizens in America don't have an understanding and therefore not an interest because they can't understand. I'm wondering what we've done on a broader scale to try to bring communities in and to break this issue down in a way that we can start to generate more public interest and therefore more pressure to fix a system that is clearly broken.
So I think all of us have engaged on trying to engage community partners and community members. Asian Americans Advancing Justice, AAJC, along with MALDEF and along with NAACP Legal Defense Fund, had for the last two redistricting cycles put together a redistricting handbook that's geared towards community members and really trying to break down the complexities of the process and explain why it's important to engage and also to provide different opportunities to engage, right? So clearly the most effective, which many up here as well as in the audience have done, is being able to produce a map that would provide a full map that provides the districts as you see as being most beneficial to your community. But not everybody can engage at that level. But that doesn't mean people can't engage, right? And so I know that, for example, Asian Americans Advancing Justice Los Angeles spearheaded an effort for the entire state of California for the last several redistricting cycles where a key component is to go out and engage with community members and have them testify at public hearings and produce, as well as producing a map. And I believe a unity map was created with MALDEF and the African American Redistricting Collaborative for the last redistricting cycle. So I think that these are all ways, and Justin in his previous slide had put together this fabulous public citizens guide to redistricting. So there's certainly efforts, but as everything, it's resource intensive, and really it not only resource intensive, but making sure we get the resources in a timely fashion so we can get the information out to people when it will actually be effective.
And I would just add that technology has made a process that used to be accessible to only a few really accessible to anyone. I mean, you used to, this is before my time, but you used to have to draw maps by hand and color them in and the rest of it, and so only a handful of organizations could really participate at that level. But technology has made it possible these days for anybody with good training, and we all engage in that kind of training when redistricting comes every decade, can draw their own map and submit it. Now, I will say, as a footnote, that depending on what the court does in Whitford, depending on how, if it adopts a partisan gerrymandering test, how that is defined, that could complicate the process and goes in the other direction. Now, how far it goes in the other direction in making the process more arcane and therefore less accessible to the general public is an open question, but it's certainly something to keep an eye on, because we do want to have as much participation to the level of actually submitting district lines as possible.
And those don't, I agree with everything that's been said, those don't just have to happen for statewide maps, right? You don't have to be able to redraw Texas in order to engage on the topic. It is plenty for people to be able to tell map makers and other decision makers like courts, which actually rely on this testimony, hey, this is my community, right? I don't need to be able to draw all of the lines of all of a state in order to be able to talk to what I think my community is and where I think my neighborhood is. And boy, if you want to make this accessible, just talk about the school board. Because anybody that has ever been through a fight over a school board understands instantly why it matters, what the stakes are, and what they can do about it. And it turns out that lots of people have engaged on that level. And this is part of why I talk about the importance of local redistricting. Those are governance bodies too. And those are ones that people, when they do choose to engage, it's immediately accessible what that means. It's a great place for a lot of people to start.
I'm just wondering if someone on the panel could speak to how, when you have a rapidly growing community, you can demonstrate that a district that's drawn in a particular fashion is going to serve that community when there isn't a long history of elections where you can show that people voted similarly and so on.
So you generally do have to have enough of a history that you can evaluate racially polarized voting. So you can't have a community that's sprung up overnight, but that's not generally what we're talking about. We're talking about communities that have grown over a decade or so to a point of significance, and you can, based on past electoral behavior, model and extrapolate how that is likely to play out in the future. And that's usually where the debate in these cases is when you're talking about a newly growing community. It often means that you're looking at not necessarily elections at the level you are evaluating, though you may have some of that, but at elections at another level, exogenous elections, whether that's statewide votes or votes on propositions or votes in a slightly larger jurisdiction, so that you can extrapolate what the newly grown community is likely to do in the future, and whether you're able to draw a district that will function to allow that community to elect its candidate of choice. It's scientific in a sense, but it is art as well as science, so you're evaluating and predicting what will happen in the future based on the past, not obviously necessarily the exact same voters, but that's true in any community because we've always got our voting population is dynamic because people age into voting, others pass away or move, so you're always looking at a group of voters that is different than the group that you've got today or you're going to have in the future. The problems are exacerbated when you have a community that is reaching that level of maturity, but it just makes the debate more vigorous about what the past says about future predictions.
The lady in the far back there.
Thank you, the lady in the far back. Thank you, panel. It's been an excellent and informative discussion, and I want to piggyback off of what Justin was saying about local redistricting. I think most of the noise is around congressional, and that's what people write about and hear about. But I want to talk about judicial districts and I want to hear what you all are forecasting for that. You know, we're seeing enormous threats to the courts and to judges and to the rule of law. And I'm concerned about judicial redistricting coming up, and we know that we get judges of color when there are districts, it's, I think, helpful. And so what do you all have to say about that? Are you forecasting anything for 2021 with judicial districts?
I mean, trouble's coming. People are learning, and you can look to North Carolina, which has been an innovator in trouble for a little while now. They just recently attempted to do away with their primaries so that they would have more time for judicial elections, so that they would have more time to redraw the maps. This comes swiftly on the heels of making judicial elections that were nonpartisan into partisan elections. And so, yeah, you can pretty much expect that when there is an opportunity to seize power in another branch of government, that some of the actors who are in charge currently will take advantage of that power. And I would expect all the same trends that we've talked about today, where we've seen in state legislative and congressional elections and local elections and special district elections like water board and things like that. I would expect them for where judges are elected as well.
And the only thing that I would add, of course, is maybe it's not fashionable to say it in voting arenas, but we vote on too many things in this country. We should not be electing judges, and that's the necessary reform. We're going in the wrong direction in states like North Carolina, but we have to, I think, start to work to limit what we elect. I would add, in addition to not electing judges, I don't know why we elect sheriffs. We appoint police chiefs. They tend to be more professional than the sheriffs who get elected. Note Joe Arpaio and several others across the country. I have questions about whether we should elect district attorneys. But we in the voting arena have to value voting, but recognize, in my view, that we elect too many offices in this country and have to move in the right direction on that issue.
We could go on, but we have limited time. I'd like to thank the panel very much for their remarks. The lunch session will begin at 12, and we have a very interesting lunch session and further sessions throughout the day. Thank you very much.